I'm not sure when it first started, but over the past few years, it seems my social feeds have been regularly filled with beers named after or art inspired from my favorite breakfast cereal, candy bars, or childhood cartoons. While I'm all for nostalgia, sometimes it seems like the branding flies a little too close to the sun. Today, I'm excited to be joined by Brandon Selinsky of Beer Law HQ for a conversation on trademarks and copyright infringement. But Brandon, first, who are you and what does Beer Law HQ do?
Hey, Andrew. I'm Brandon Selinsky. We're Beer Law HQ. We're in Denver, Colorado. And what we do is we do beer law. It's truth in advertising right here. So we are an arm of a law firm. The law firm is Whitcomb Selinsky. So it's myself and Joe Whitcomb. We have a law firm. We're about 15 attorneys strong. And we have, like a lot of law firms, a number of different departments and different focuses. Mine, amongst other things, is beer law. And so with Beer Law HQ, Beer Law HQ is powered by the law firm. And it's worth talking about because it's not just me. It's the entire law firm, which means that you've got the background and experience of somebody like me who's really into the specifics of trying to get breweries up and running and making sure that they are compliant and avoid legal citations and things like that. But then you get other folks in the firm that have other specialties. I've got an attorney that worked for the Department of Labor for 7 years. That's Tim Turner. Tim Turner knows everything that you ever need to know about OSHA. That was one of his specialties at the Department of Labor. So, if you got an OSHA question, we've got Tim to help you out. If you had a question about structure or organizing your brewery or organizing with another brewery, we have a bunch of folks that do corporate law. We have a litigation department in case you really get into trouble or you want somebody else to get in trouble. So it's an entire collection of attorneys with different focuses, a lot of which lend themselves to beer law.
So why are you so passionate about beer law and why did you decide to add it to your repertoire?
I'm passionate about beer law in part because I'm passionate about beer. And I'm always cautious about saying that because I'm not the only guy that likes beer. I get that. I'm not the only attorney that likes beer. But that is kind of what got me started and what got us started. And so while I really like beer and I homebrew and all that, and that's great, that doesn't qualify me to do anything in terms of organizing a brewery or helping you get your trademark registered. However, it goes hand in hand with what our law firm has done for the last 10 years. Today's our 10-year anniversary party. So we've been
Congratulations. Sounds like a great time.
Thank you very much. Yeah, we're really excited about it. Hitting that 10-year mark is a big deal for any business of any size. So we're excited about that. But one thing that we focus on and the common thread through all of our practice areas is that we are government facing. So we get things from the government for our clients, whatever that means. That could be Social Security or VA disability benefits. It could be getting a contract awarded to our client, lots of different things. And beer law is the same thing. It's almost always government facing. Sometimes it's a B2B situation. It might be against another brewery. We do that too. But the point is, it's just navigating that morass of government regulations and things like that, knowing where to go to get what you need and being able to get it.
I feel like I didn't do a good job if I didn't ask. Did you brew a special beer for the 10-year anniversary tonight?
I didn't. I wish I had. My system's down right now. I'm converting over to an electrical system. And so I didn't get to do that. The one I have on tap right now is one that I made a little while back. Mockery Brewing had a homebrew contest. So the one I have on tap right now, it's a ginger lager.
I feel like you're a little ahead of me getting back in the game. Ever since I had my almost 3-year-old, I haven't brewed, but he's about at the point in his life he's ready to be a helper. So I think I need to get back in the game too.
That helps. My youngest just turned 5. So they know that the last thing they said was, all right, we want to help you brew your next beer. Like this is, I didn't ask them about it. And we understand that we can't put the hops in because that's dangerous. You're exactly right. Got to stand behind the line when we're doing hops.
Well, make sure you're paying them for their work, Brandon. We don't want to take advantage of anybody in the brew house.
Yeah, for sure.
Well, let's dive into today's conversation. I want to start with the basics. What are the differences between a trademark and a copyright?
Great question, because they do tend to overlap when we're talking about beer law. So a trademark identifies the source of a good or service. That's usually a name or a logo. That's what we think of when we're talking about trademarks. A copyright protects a work, what they call a work of authorship. So that's art. And the overlap here is when you were talking about label art, for example. So on your label, you might hire an artist to create a graphic for you. And you might hire somebody else. You might think up the name yourself, and you marry those two things together. You're going to have some copyright to that label, and you might also have a trademark right to that label. So the two might overlap. They're not the same thing. And if you talk to an attorney and you ask for help with your copyright, and you're really talking about trademark, who cares? We're going to know what you're talking about. But it's worth knowing the difference, so that you can have an intelligent conversation about it.
So when a brewery is putting out a new beer, should they be looking into getting a trademark and a copyright, or what do you see most common when a brewery is, putting out that special release that, they want to make sure is their intellectual property?
It depends on what they do. And a lot of my answers start with it depends. I'm sorry about that. It's kind of a professional thing. It's just how we answer most questions, but it does depend. If your label is a green background with a white stripe, that's not protectable by copyright. That just isn't interesting enough. There's not enough creative input. But if you hire somebody to create, a monster or some sort of display in the background that does have some significant creative input, then it might be worth registering that copyright. And it's cheap. I think it's about $45 now to register something as a copyright through the Copyright Office. Most places don't bother with that. And that's not usually where a fight is had, but it does happen sometimes. And so if you're investing in your label art, it's something you should think about.
And is that something breweries can typically do themselves, or is it easiest to hire someone or find someone, with experience like yourself doing things like that?
Of all the kinds of intellectual property, copyrights are probably the easiest DIY. I mean, if you fill out a form, you attach a copy of whatever you're trying to protect, and you send it in, and that's kind of it. There's not too many ways you can trip yourself up there. Trademarks, on the other hand, completely different story. So if you are coming up with a name of your beer, again, it might not be registrable. You might not be able to file for a trademark, because if it's your brewery's pale ale and that's the name of your beer, all right, great. No one's going to steal that, because they would have to steal the name of your brewery. And hopefully you've got the trademark protection that you need in place for that. But if you're coming up with a brand new name, there are things that you should do to make sure that, first of all, that you can use it. And then second of all, that you are managing it properly. So, if you want me to get into it, I'll get into the specifics a little bit, Andrew. Just stuff you can do at a really basic level. So you brew a new beer, you name it Unicorn Pale Ale. So the first thing you do is you plug Unicorn Pale Ale into like Untapped or something like that. At the very least, Google it. So you see if there's another brewery out there or beer that's got the name Unicorn in it. And if it does, that might be a stopping point for you right there. Or it might not. If there are 50 other beers with the name Unicorn in it, no one's going to care. And you can use that, but it's not going to be unique. So the main thing that you want to do when you before you launch your beer is just plug that thing into Google or Untapped or something like that, just to make sure that you're not going to get an immediate cease and desist and have to relabel.
So when should a brewery decide to trademark a beer name?
When it is a beer name that you're going to keep around for a while, and that that you want to protect, and you might want to protect it for a number of reasons. The biggest reason is you don't want another brewery to use that name. So if it is going to be your flagship beer and that thing's going to be around a while, you want to make sure that that name stays unique. Then you should think about filing a registration for it. And it's important to know that if you do your search or you hire an attorney to do a search and you don't have rights to that name, that's not necessarily a stopping point. You might still be able to use that name, but you're adding risk where it's unnecessary. Probably your best bet at that point is to change course. Find a different name no one else is using, have that be the name of your flagship, and then you're good to go.
No, let's say I open a brewery, I start using Unicorn Pale Ale, no one else is using it, but I don't trademark it. 5 years down the road, another brewery opens up. Let's say it's your brewery, Brandon. You open up and you really like unicorns and you go with, Unicorn Pale Ale. What does that mean for me? You start using that name. Is that something I can enforce even though I don't have a trademark? Or what's a situation like that look like?
Yeah, absolutely can. You don't need a registration to have a trademark right to something. Using it in commerce, so basically using it to sell goods or services, gets you a trademark right. Now that's a common law right. You're not going to have a federal right. And the difference, without going too deep into it, you'd rather have the federal right. I mean, you'd rather be able to sue somebody in federal court if it comes down to it. And even if it doesn't come down to it, you can wave around that registration and scare a lot of people off. So let's say that happens, and you, if I keep using that name, if you let me keep using that name, you are liable to lose your registration, or at least lose the exclusivity that comes with that registration. You got to tend your fences. So I'm out there. You have to do what you can to stop me from using Unicorn Pale Ale. So you send me a cease and desist. And I get that cease and desist, and I say, nah, I don't care. Andrew and I are in two different places. I'm not going to worry about this. Well, then it's up to you to figure out what your next move is. And that might be sending a takedown notice to an internet provider. It might be filing a lawsuit. It might be launching a campaign against the other brewery, against me. So you have some options, but what people miss, what businesses miss in general a lot, is that when you file for a registration for a trademark, or you just have a trademark, enforcing that costs something. So know that. Know that you get that registration and use it to your advantage. But if you're going to enforce it, it's going to cost you some money. And so you have to kind of make that decision. Is it worth suing somebody to keep that registration right?
Yeah, I'm sure it can definitely become a costly process. And to go back what I started with, I've seen quite a few breweries, take a candy bar name, for example, and name their beers off something very, very similar and have the art resemble that said candy bar. Then these breweries go and they receive a cease and desist letter and they wear it like a badge of honor. I've seen this happen quite a bit. What are your thoughts on those that, have the beg for forgiveness approach?
It works a lot. In fact, it'll probably work most of the time for exactly what I was just talking about, the exact reason. Even if it's a large brewery or a larger company, if it's Nestle or someplace like that, they don't really want the bad press that comes with a lawsuit, and they don't want to invest in a lawsuit. They don't want to. They'll do it because, boy, they have the money for it. But you get that free publicity, and I've talked about this in webinars that I've done. When a small brewery uses the name of a slushy, for example, this came up a couple years ago. And then the company, sends you a cease and desist or politely asks you in some way to take that down. You can't do it. And then you've got a bunch of news articles now that say that, the big guy came after me, the bully, and made me take this down, and I'll do it. But boy, it's just not fair. The truth is it is fair. But who cares? You got away with it. You got some free publicity. The other side of that, though, is every once in a while, a large company is going to make an example of you, and they will sue you, and it will hurt if they do that. Just defending the lawsuit is going to be really expensive and unpleasant. So there's some risk to it. I don't advocate for it, but honestly, it works out sometimes.
That was my next question. You're a lawyer, not a marketing specialist. So don't take any Brandon's advice as he's telling you to use this as a marketing campaign.
For sure.
Now, Brandon, what are some of the issues and pain points you see craft breweries currently dealing with today from a legal perspective?
Well, trademarks is always one of them. And I blame our trademark system for that. It's a little clunky. It's not terribly fair for smaller businesses. And it's not fair because if you're a smaller business, like I said, it costs money to register a trademark, to defend it, all that kind of stuff. And so there's definitely a resource advantage. But there are other things right now that breweries, are kind of feeling the pain on. One of them is transitioning. And so if you're trying to sell your brewery or sell a stake in it, if you're trying to merge with another brewery, collectives are becoming a bigger and bigger thing. It's a way to pool resources rather than sell out to one of the big guys. You can become part of a collective and or a smaller company. So figuring out what the value of your company is, getting that value, you negotiating that deal, and honestly, just doing the paperwork, the mountains of paperwork that go along with that kind of transition, that kind of planning. We do that. So I'm not here to pitch myself, but just kind of circle back as to what Beer Law HQ is. That's one of the things that we specialize in. My partner has a master's in law in international business transactions. We do a lot of corporate law in general. So we do that kind of thing. You want to find somebody that's got some experience doing mergers and acquisitions when you do that. Some of the other pain points are just TTB stuff. That's always a pain point. And I'm not here to dog the TTB. They're a thing. They're made up of real human beings, and they're trying to get their job done. But they cause some headaches sometimes. So that's something that, if you can have somebody dedicated at your brewery to managing taxes, to managing compliance, that goes a long way to making sure that you don't get those headaches from TTB.
Understood. And, brewery owners wear so many different hats, and sometimes it can be very valuable to pass this along to someone with more expertise on the matter to make their lives easier so you can do what you love, and that's brew delicious beer and run your brewery.
Absolutely. Yeah.
Now, Brandon, in the news lately, we've seen a lot of cases about trademark disputes between breweries. Can you tell us about a case study that you've seen a craft brewery go head to head against a larger brewing company and win?
Yeah, I mean, this isn't. I almost feel like you're pitching me a softball on this one because of the timing of it. The Miller Coors Stone Brewing case came out just 2 months ago, and it's one I like talking about because of all the times that I've discussed trademark issues and what you should do and what you shouldn't do, and these are the risks, resources, and all that. This was a case that kind of turned all that on its head. I mean, it was, for those of you who don't know. Stone Brewing, which is based in California, they sued Miller Coors. They sued it because Miller Coors was using the Keystone abbreviation Stone. So they started marketing Keystone beer, which is one of their brands, as Stone, and it was in all their marketing. It was on the box, on the cans, I think, and it clearly said Stone. And so, just to nerd out for a second here, the standard for trademarks is: are consumers likely to be confused? And so Stone Brewing said, well, you're using the word Stone. We have a registered trademark for Stone, for beer. And so people who are going to buy your beer are likely to be confused. And Miller Coors came back and said, well, that's silly. You guys, everyone knows that you're Stone Brewing. Keystone is an iconic brand. Everyone knows what it is. No one's being confused. And the long story short is the jury found that not only were consumers likely to be confused, Stone was damaged to the tune of $56 million. So it was a huge verdict. I mean, a huge win. But it's also complicated because Miller Coors they're a $10 billion company. So $56 million, they're not going to feel that too hard. Stone, on the other hand, probably felt it. I mean, this is a hard one, it was a hard win, a hard fought win. And it probably cost them something in the meantime. I don't know what kind of relationship they had with their attorneys, but if you're paying hourly for that kind of stuff, that cost a lot of money to get through that. And they had to put up that money, most likely. So it wasn't all glory and glamour and glitz, but it was a big win. And it's one that, maybe it'll have an impact down the road. I hope, in terms of having smaller breweries be able to assert the rights that they have to their marks. But I guess we'll wait and see.
So kind of go back to something we talked about earlier. So once you have this trademark, is it your obligation to enforce it in every situation that you want to make sure you have the rights to it? Or can you kind of pick and choose who you go after based on how large their company may be?
More the latter. Yeah, you have to tend your fences. Absolutely true. And your best bet is to leave no stone unturned. So even if it's mom and pop's brewing in Greenbow, Alabama, and that's nowhere near you, your best bet is to make sure that you send them a cease and desist. Now, best practices aside, it's almost, I don't want to say it's unlikely, but it's not terribly likely that mom and pop's in Greenbow, Alabama is ever going to cause you any problems. But if somebody else says, well, Rainbow Pale Ale, mom and pop's is using that name, and you didn't enforce your trademark against them, so therefore you don't have exclusive rights to it, that's where it can come back and bite you. Mom and pop's isn't the problem. It's just knowing that somebody is out there infringing on your trademark. A third party might come along and say, well, you've just invalidated your trademark. So that's why I was saying before that our system is not built in a way that is a lot of fun for breweries, because you wind up, this is another dimension of the Stone Brewing case. Stone has a reputation for enforcing their trademarks against smaller breweries, being the Goliath in this David Goliath fight. So that's why I kind of like that case, because they've been on both sides of it. But they're pretty thorough. And I think that anytime something pops up that looks like Stone Brewing, they get on top of it. And that is really what you should do. I hate to say it because that costs money and no one likes to have those fights. But I want to take that a step further, because cease and desist are not the only way to manage those things. You could also have a coexistence agreement in place. So you might say, all right, mom and pops, you can use Unicorn Pale Ale as long as you use it only within the bounds of Greenville, Alabama. And then I've got the rest of the United States to sell my Unicorn Pale Ale. And that's legit. That's tending your fences. And if somebody comes along and says, you're not doing that, you don't have exclusive rights, you can waive that coexistence agreement in their face and say, yeah, we are, and you can't use it.
Do you have any tips or tricks for breweries to make sure no other companies are, say, using Rainbow Pale Ale? I mean, should they simply just set up Google alerts? Should they be searching regularly on Untapped? What are your best practices for making sure no one's using your intellectual property?
Yeah, those are two good ones. There are also companies out there that monitor trademarks, and that's all they do. And we don't typically do that. I have a handful of clients that I do that for. And it really is a matter of periodically tagging in. So Untapped, Google, sure, Google Alerts is great for that. But you can also go to the PTO website. So that's the trademark office, the US Patent and Trademark Office. Check their database from time to time. They publish marks quarterly, and you should pay attention to that. That's actually how a lot of cease and desist letters are generated, is somebody is paying attention to those publications. And what that is, just to give you a little bit more on that, when you apply for Rainbow Pale Ale and you file that application with the PTO, it sort of goes through a process, and they look at it, make sure that everything's okay, that it's you're able to register that, it's available, and then they push it on to the publication stage. This is still the PTO, and they'll publish it in their own publication, and you get 30 days. The world at large gets 30 days to file an opposition to it. And if no one does, or no one files for an extension, then that window closes, and generally after that, the trademark issues. So you want to pay attention, because that's the easiest way to object to something is within that window, or even before that. There's a way to do it before that window opens, but generally that publication window of 30 days, you want to know when that is. So get some of these things in place. The Google Alerts, if you're on Untapped regularly, that's super easy to use. And then the PTO, because you don't want something to get through and get published, and then a mark get registered when you had the opportunity to cancel it.
Awesome. Well, thanks for that insight, Brandon. Now, we've talked a lot about trademarks. I want to go a little bit back to the label art conversation. What are some of the mistakes you currently see brewers make?
They're generally innocent mistakes, I think, but it's just not paying enough attention to the label art that's already out there. Or another one, this was one that I've talked about in my webinar before. There's a North Coast Brewing had some problems with its label art. A couple of good, I thought, very interesting cases. And they had to do with contracts. I mean, read your contracts and definitely know what you want your contract to do. Contracts are not some mysterious thing that no one but attorneys can read. That's common misconception. You read your contracts and know what they say, know what you're agreeing to. Because if you're getting a license, for example, let's say you hire an artist to create something for you, or something's already created and you just want to license that art to put on your labels. Know what that license is for, and when and how it can be canceled, whether it can be canceled, and who has the right to it. If the artist passes and somebody else then has that right, does that change at all? I ran into a similar problem recently. I had a friend who, unfortunately, his uncle passed away, and he's been trying to manage the estate. And he got an attorney, had me review some of the contractual things that the attorney did, just because I like to edit things. I'm a compulsive editor. And so I did that, and I made it read a little bit better. And he showed me the response from his attorney, and his response was, well, I guess you didn't really like the legalese that I use. Sometimes attorneys have to do that. That is not true. It's absolutely false. You don't need legalese for a contract. You just need it to say what you want it to say.
Awesome. Good insight once again, Brandon. So we've talked a lot about tips and strategies breweries should be doing to protect their intellectual property, but are there any additional proactive ways, breweries can do so?
There are some other kinds of intellectual property. So registering is the gold standard. If you can register your copyright or register your trademark, you can't do anything more than that, aside from maintain those registrations by tending your fences. But there are other things within breweries that you may want to keep secret. So there's a different kind of intellectual property called trade secrets. That's something that can be useful. It depends on how secret you want to be, because some breweries will, they'll publish their recipes. I got a recipe from a brewery out east. I read about their beer. I thought it was super cool, and I emailed the guy, a famous brewer, and he emailed me back right away, sent me the recipe, said good luck. And I made it, and it was like one of the best beers I've ever made. So some brewers are really great about that, but some brewers want to keep their recipes secret. They want to keep their process secret, maybe their accounts and things like that. So you can do that. And it's important to know how to do that, because once you open the door, you can't close it again. You can't unring the bell, as they say. So for example, if you want to keep your account secret as a trade secret, you keep it under lock and key, and that might mean keeping it password protected. You don't actually have to have a vault anymore. You can just make sure that only the people who need the information to those accounts can get to it. So you keep it under lock and key. You keep only give access to the people who need it, and make sure it doesn't get public. And that's a way that you can keep some of these things secret if you want them to be secret. But I would say beyond that, we deal with a lot of government stuff, and some of that stuff is top secret, and it's such a pain to keep stuff top secret. You have to jump through a lot of hoops. And so to the extent that you don't have to do that, don't do that. I mean, everyone knows how to make a pale ale. Just because you used, this set of hops, I would humbly suggest, from my view, that probably that doesn't mean you need to go through and set up a lot of these protections. But for things like accounts and other stuff like that, that really is unique to your brewery, that might be something you protect.
Awesome, Brandon. Thanks for sharing that. And one thing I know I'm looking forward to, we've talked a lot about trademark. We talked about copyright infringement, label art today. But one thing I really love is just seeing people in person. And I get to see you in about a month. You're going to be joining us in St. Louis for CBP Connects. It's our in-person workshop. It's going to be June 20th to 22nd. Half networking, half education. Brandon, I have to ask you, why are you excited to join us in St. Louis?
Well, first of all, St. Louis is a great town. It's a great beer town. Second of all, I love meeting people through CBP. You have a great organization going, and I like some of the things that you set up. So I can't wait to see who shows up there and just be able to talk beer law. I mean, as I mentioned before, one of my specialties is trademarks. I can kind of talk about trademarks all day long, for better or for worse. So if anybody wants to have a conversation about trademarks or beer law, I can't wait to do that. But also, like I said, hanging out in St. Louis is super cool. I had a case there in 2018, so I was going back and forth to St. Louis a lot. Looking forward to kind of getting to know that town again.
Did you happen to have any favorite places you stopped by while you were there that year?
I didn't have a lot of time for beer while I was there. I wish. I'm going to find some places this time. So anybody who's got some suggestions, send them my way.
And we've got 3 nightly receptions. So anyone looking to have a conversation with you over beer law can do so 3 nights in a row. It's going to either be at Perennial or be at Four Hands Brewing in the Schlafly Tap Room. Good beer, good conversations. I know I can't wait to meet you in person, Brandon. I feel like I know you through the screen, but excited to take it to the next level. And, what else can we expect from Beer Law HQ coming up?
Well, this summer we're launching a whole series of webinars. These are educational webinars. They are supposed to kind of dovetail with the publications that we're going to have. So we're going to do a bunch of blog posts about different beer law elements. The one that we have coming up is about TTAB. So TTAB is the Trademark Trial and Appeal Board, and that's where you have fights at the trademark office. And something that I love to do, because it is an opportunity for my client to get in and kind of do litigation light. I mean, it's a way that we do discovery and some limited motions practice and all this kind of stuff that you do in court, but it's much, much cheaper to do it at TTAB. So if we're just fighting over trademarks and that's all they do, then that's the place to have it. So we'll talk about a little bit about how to do that, what to watch out for. It's something that you don't need an attorney for, but it's a bad idea to try to go that alone. It's, there's a lot of regulations and you can trip yourself up pretty easily, but that's why we're going to talk about it. So that is June 14th. Hey, that might be July. Hang on. Let me check my calendar here. I think it's July 14th July 14th at 1 p.m. And it's virtual. So you'll see me sitting right here at my desk.
And for anyone looking to register for this or just learn more about Beer Law HQ in general, how can they do so?
You can go to our website. It should be, I think the sign up is already on there, but I'll check and make sure that if it's not, it will be shortly. Beerlawhq.com has all my contact information. Send me an email. If you just have a question about beer law or some small business element in general, send me a question. I won't charge you for an email, and we'll figure out if we can do something for you.
And for everybody who's watching on YouTube, we've dropped the link in the comments where you can register for that webinar in July. And for everyone who's listening on Spotify or after the fact, just check out beerlawhq.com. And your email, once again, Brandon, so anybody can reach out?
Brandon@beerlawhq.com.
Easy enough. Brandon@beerlawhq.com. Brandon, I appreciate all the conversation today. It's always a pleasure to learn a little bit more. And I look forward to seeing you in St. Louis. Congrats on the anniversary.
Thanks very much, Andrew. Thanks for having me on. I appreciate it. And yeah, we'll see you in St. Louis. Take care.
See you in a month. Cheers.
Right. Cheers.
Bye.